All right, well, welcome to our webinar today. This webinar is actually a recording of our follow-up webinar that was done on April 1st called COVID-19 HR and Financial Advice for Northeast Minnesota Employers. And today is our update to that webinar. We had our update a little earlier today, and we realized afterwards that there was a little technological problem, and the presentation we did a little earlier today was not recorded. So today is our recorded version, or this afternoon, I should say, and we're going to actually be publishing this on YouTube in two different sections, the HR section and the financial section, so that as you're looking through this on the web, you'll be able to more quickly access the information that you need. So this particular portion of the webinar is my portion, and it's about the HR side. Our webinar hosts are, of course, myself. My name is Justin Turch, and I'm the managing consultant with Turch and Associates. We are a small HR consulting firm in downtown Duluth. We have two full-time and two part-time HR consultants, and we office with the CPA firm of Anderson, Coedy, and Asuma. And Craig Chilcote, the managing partner of that firm, will be doing the financial portion of our presentation. And as I said, we've done this earlier today, but we realized there was a problem with the recording, so we're just going to do a run through so that anybody who was going to access it later is able to do so via YouTube. So I'll let Craig do his own introduction for his segment of this presentation, and we'll just stick to the HR side here. So the first thing is I wanted to provide an overview of the legislation that we're talking about today. As many of you know from our first webinar on April 1st, the Congress passed the Families First Coronavirus Response Act. And that act did many things, but it especially created two new laws called the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Act. And while we were doing our webinar on April 1st, the Department of Labor actually issued its guidance and its rule literally while we were talking. So a lot of the things we were talking about in our webinar on April 1st has changed because of the way the department is interpreting the rule and the law. So today is really about the things that have changed. If you're looking for a more comprehensive view of the Family First Coronavirus Response Act, our YouTube channel has that webinar in its entirety right on there, and you can access that. So the best way to look at this is to separate the two acts from emergency paid sick leave with the Emergency FMLA Act. So let's start with the sick leave. So the benefit under the Emergency Paid Sick Leave Act is that eligible employees get 2 weeks of paid time off if they meet certain criteria. If you're a full-timer, that means 80 hours. And if you're a part-timer, there's a special calculation to get to the number of hours. And we talked about that in that webinar on April 1st. So if you haven't, you should watch that because it tells you a little bit about how you get the average hours worked. To be a covered employer under the Emergency Paid Sick Leave Act, you need to be a private employer with fewer than 500 employees or a public sector worker. There are some exceptions to the public sector, but they really only apply to certain federal employees. There is an exemption for some small businesses with less than 50 employees, and we're going to talk about that here in just a bit. And you'll want to stay tuned if that's important for you. To be a covered employee, however, there is no length of time requirement. So an employee who was hired yesterday would be treated the same as an employee who was hired 2 years ago. All employees, regardless of hire date, are covered under the Emergency Paid Sick Leave. Now remember, there's two acts. There's the Emergency Paid Sick Leave and the Emergency FMLA. On the Emergency Sick Leave, all employees, regardless of length of employment, are covered. It applies to part-time and full-time employees. Doesn't matter how many hours a week they work, but they must have a qualifying reason. There are 6 qualifying reasons under the Emergency Paid Sick Leave. The first is that an employee is subject to quarantine or isolation. The second is that the employee was advised to self-quarantine by a medical provider. And the third reason is if the employee has symptoms and they're waiting for a diagnosis. So those are the first three. The second three include an employee who's caring for another individual who's been quarantined or advised to quarantine, an employee who's caring for their son or daughter because school or childcare has been closed. And the sixth reason is other substantially similar conditions as defined by the Secretary of Health and Human Services. So we'll go over the rule that came out on April 1st as it kind of modifies each of these and helps clarify. So under the first provision, employee is subject to quarantine or isolation order. The department confirmed that a stay-at-home order from a state is considered a quarantine or isolation order. So for all employees in Minnesota and Wisconsin, if they're not an essential business or essential occupation, and therefore they can't work, if you would have otherwise had work for them, then they are entitled to this 2 weeks of paid time off. So let me say that again. If the employee would be working for you, but for the governor's stay-at-home order, then the employee is entitled to 2 weeks of paid time off. If your business was already closed down because of lack of work, for example, then you wouldn't have work for the employee, and therefore you do not need to pay the emergency paid sick leave for 2 weeks. But the burden will be yours to kind of demonstrate that. So I encourage you to be conservative in your approach, okay? If the employee's home because of the governor's stay-at-home order, but you have work for them to do that can be done through telework, then you don't have to pay them. They can do the work through telework, and I would encourage you to do that. Number two, second reason is that you haven't been isolated or quarantined, but you would have been advised to self-quarantine. So the rule states that employees are eligible for the 2 weeks of earned paid sick leave if a healthcare provider advises the employee to self-quarantine on the belief that the employee has COVID-19, that they may have COVID-19, or that the employee is particularly vulnerable to COVID-19, and that following the advice of the healthcare provider prevents the employee from being at work. So for instance, if you had an employee that had a significant diabetes or a significant heart condition or a significant lung condition, and the employee didn't have any symptoms, there's no issues, but the doctor said, you know what, you probably should stay home because if you get COVID-19, you know, you're going to be at real high risk. If that was the case, and the employee could do their job from home through telework, the employee is not entitled to earn paid sick time because you're allowing the employee to work from home. If you don't allow the employee to work from home, or the employee can't work from home because of the nature of their job, then they're going to be entitled to the paid emergency sick leave. So again, your way out of it is almost always if you can provide work from home opportunities. Qualifying reason number 3 is the employee has COVID-19 symptoms and they're waiting the results of the test, okay? Now the employee has to be waiting for a COVID-19 test. They can't be waiting for, because the doctor thinks they have some other illness. It has to be COVID related. The department also clarified that if the employee is advised by the clinic or the hospital that they can't get a test because of a test shortage, that they should also be considered to be awaiting the results of. So essentially they would be entitled to emergency paid sick leave as well. Now, you may have a situation where the person has symptoms, but they're mild, and the employees decided that they could work. If the employee can work from home, you don't have to pay sick leave. So again, you're seeing a theme here. If the employee can work from home, you don't have to pay sick leave. If the employee has symptoms that are so severe that they couldn't work, then they're going to be entitled to paid sick leave. So those are the first 3. The employee is subject to a quarantine. The employee's been advised to self-quarantine, or the employee has symptoms and is waiting diagnosis. And remember, different reasons have different amounts of money that you have to pay the employee. So that's covered under our first webinar. And I really encourage you to refer to that. So let's look at the other 3 reasons. So reason number 4 is caring for an individual who's quarantined. So an employee would be eligible under the new regulation for earned paid sick leave when they're caring for an individual to whom the employee has a personal relationship, and during the time when the individual has been quarantined or advised to quarantine by a healthcare provider. So let's talk about what a relationship is. An individual means an employee's immediate family member, a person who regularly resides in the employee's home, or a similar person with whom the employee has a relationship that creates an expectation that the employee would care for that person. This is the language out of the regulation. So when we're using those terms, what that means is it might be a boyfriend or girlfriend, it might be a sibling, it might be a grandparent or grandchild. It doesn't necessarily mean an immediate family member. So when you're looking at this, realize that there is some room on both sides of this, and you should probably interpret that a little liberally for the employee. Reason number 5 out of 6 is caring for a son or daughter. We're going to talk a lot about this provision in the FMLA section. But caring for a son or daughter entitles an employee to get emergency paid sick leave, again, that 2-week period of time, when they're caring for their son or daughter because the child's school or daycare is closed as a result of COVID-19. And no other suitable person is available to care for the child during the period of the leave. So you may have a situation where you have an employee requesting leave and you know that the employee's significant other or spouse or whatever, child's other parent, doesn't work. You know, theoretically, an employee who's got a stay-at-home partner who is able to care for the child should be the one caring for the child. And in theory, an employer could deny leave if there was another suitable person available and the employee just didn't want to let them watch the child. They preferred to do it. Key question is, of course, who determines who's suitable? And you want to be careful in your interpretation of that and make sure you're on the right side of that. Interestingly enough, the regulation clarified that a son or daughter is broadly interpreted and it might include an adult child. If the adult child's incapable of self-care due to a physical or mental disability, that child may qualify just as much as a 2 or 3 or 10-year-old child. So don't automatically deny the request for leave if the employee's child's an adult. Ask why the child's not able to care for themselves. We might see this with people who have adult children with Down syndrome or cerebral palsy or things like that. It's a reasonable possibility. And then number 6 is other similar reasons. And the Secretary of Health and Human Services has not made any of those potential reasons public, at least that I'm aware of after doing my research. So it's kind of a moot point, number 6. There are limitations on intermittent leave. So for those of you who have a company or organization where you have to administer FMLA regularly, you're probably very familiar with intermittent leave. Intermittent leave is the type of FMLA leave that isn't in big blocks of time. The employee might leave early, come into work late, leave during the day for appointments. It's not where they're just gone the whole week or the whole month. Under the new regulation, intermittent leave is generally not permitted unless the employer and the employee reach an agreement that's explicit as to their understanding. Now, the agreement specifically, the reg specifically states that the agreement doesn't need to be in writing, but it does need to be clear. My recommendation is that it would be in writing if you're going to allow an employee to do that. All right, so we just got done talking about emergency paid sick leave. There are 6 reasons why an employee would be entitled to emergency paid sick leave. The sick leave is paid at 2 weeks, part-time, full-time, Brand new employee, long-standing employee, doesn't matter. The Emergency Paid Family Medical Leave Act is a little bit different, and it's important to understand the nuance. So, the benefit for employees under the Emergency Paid FMLA is 12 weeks of time off for eligible employees. There was a lot of confusion originally about the first 2 weeks of that 12. So the law says that the first 2 weeks of the 12 is unpaid, and then it's paid at 2/3 rate after that for the rest of the 10 weeks. That's true, but it got people confused because the first 2 weeks of that 12 is paid. It's just paid over, rewind. It's paid over under that emergency paid sick leave, not under the emergency FMLA, but they do run concurrently. So when you go out for 12 weeks, the first 2 weeks is paid under emergency sick leave, and then you just roll into the next 10. You don't get 2 plus 12. You get 2 plus 10 if you're being absent for your son or daughter. Okay, so you're always paid. It's just under which law you're being paid. A covered employer, again, is a private employer with fewer than 500 employees. All public sector employers, except for a small group of federal employees. And there is an exemption we'll talk about here shortly for some small businesses with less than 50 employees. A covered employee is a little bit different than under that emergency sick leave. So to be a covered employee under FMLA, this new version of FMLA, you have to have worked for at least 30 calendar days for the employee. I shouldn't say worked. You have to be employed for at least 30 calendar days with the employer. The CARES Act that was passed a few weeks after this law clarified that if you laid an employee off and you're rehiring them, you should give them credit for their prior employment. So if you bring somebody back that you had laid off, you should look at the time that they had worked for you before the layoff. And then, of course, the employee must have a qualifying reason. Now, unlike the emergency paid sick leave that had 6 reasons, the Emergency Paid Family Leave Act only has 1 reason, and it's one of the same reasons under the other law. And that is to care for a son or daughter whose school or place of care has been closed because of COVID-19. Same definitions and parameters exist under the emergency FMLA leave law as it does under the emergency paid sick leave law. Same rule. You have to be caring for your child because there's no other suitable person to care for the child. And remember, that child could be an adult. Like emergency paid sick leave, there is a limitation on intermittent leave. So you don't have to allow employees to piecemeal that leave together. If you want, for your own operational reasons, to have all the employees either out or in, you can do that. You don't have to let them use an hour here, an hour there, or 4 hours like you do under regular FMLA leave. So that should be a help to some employers who find that to be a struggle to manage. One caveat. So employees are allowed to use a total of 12 weeks of FMLA leave per year for both traditional FMLA and emergency FMLA. If you are an employer that regularly administers FMLA because you're big enough, then time that an employee used for other FMLA reasons reduces the time that's available for paid FMLA. Employees may not exceed 12 weeks of FMLA and emergency paid FMLA leave combined total. But if the employees exhausted their FMLA leave, either through this emergency situation we find ourselves in now, or 4 months ago because of some other unrelated medical reason, the employee is still entitled to emergency paid sick leave, that first 2 weeks. So keep that in mind. That's always available to them. but that the FMLA leave that goes up to 12 is not necessarily if they already burned it up. All right, so how do we exclude employees? As you know, we talked about this in our April 1st webinar when we discussed the definition of a healthcare provider. And I used in that webinar, we discussed how I was using the definition that the FMLA law has traditionally used, the one that's in the statute. And then of course, we discussed how emergency responders wasn't really defined in the law. The regulation changed that. The regulation that was produced by the Department of Labor better clarified and expanded the definition of healthcare providers for the purposes only of excluding employees and that of emergency responders. So if you have employees who fall under the definitions we're going to talk about, you can exclude them from all of the paid leave requirements. So here's the definition of a healthcare provider. It's pretty broad. It includes anyone who works at, is the language, one of these places. Doesn't mean that they're necessarily in an occupation, I noted. Maybe you're a janitor at one of these facilities. You don't have to be a doctor in the doctor's office to be excluded. You can see the list here. And again, this now is being recorded. We had a snafu, so you should be able to pause and look at this definition a little closer. One question we did get was from group homes and asked if they would be considered a, fall into one of these categories. And in my opinion, they would fall into a category of any other similar institution, employer, or facility. But that's my interpretation. If you want to get a more detailed analysis, you can reach out to me directly, or you can, of course, contact your employment attorney. So the definition of emergency responder has also been defined, which is nice because it wasn't defined originally. And it is also pretty broad. So it even includes public works personnel, child protection workers, people with specialized training. Again, you may want to pause the video here to see if you qualify or if your employees qualify under one of these. All right, how do you get exempt? This is a very interesting question. The law did say that the Secretary of Labor could create guidelines for exemptions, and that's what the rule included. And so Secretary Scalia did create a process for employers with less than 50 employees. So if you got 50 or more, this is irrelevant to you. But if you got less than 50, you may meet the criteria for exemption. If you decide that you do, you must certify that reason in writing when you deny the employee their leave. And it should be in some detail, and you should be prepared to account for and defend your decision if you end up with a complaint from an employee with the department. So exemption number one, the request for leave would result in the business's expense exceeding its available revenues and cause the business to cease operating in a minimal capacity. So the word "and" means you have to meet both. You have to have basically a negative cash flow as a result of the leave, and you have to reasonably expect that it would cause your business to cease operating at a minimal level. So that's a pretty high burden, I think. Exemption number two is the absence of the employee would entail a substantial risk to the financial health or operational capabilities of the business because of the employee's skills. So the example I used when we were doing this live was that if you own a veterinary clinic and your only veterinarian requests leave, it might be reasonable to say that it would jeopardize the operational capability of your clinic. Be a little conservative in your analysis of this. If you have 10 people who do the same job and one person requests leave, you probably aren't going to meet this threshold. So it's the absence of that particular employee, not that employee's job title, but that particular employee, would entail a substantial risk. So think through that before you make those decisions. And then if you don't qualify under reason number 1 or reason number 2, there's this third reason that I do think is applicable to a lot of employers. And that is you don't have anybody else to do the job. And the job's important such that if it doesn't get done, you're not going to be able to operate. So the other kind of caveat is because this is on a case-by-case basis, the first employee who comes and says, I need emergency paid leave of whichever form, emergency paid sick leave or emergency FMLA, they might be entitled to that leave. You might not reach the threshold of reason 1, 2, or 3 with that first employee. But by the time that 10th or 12th or 20th employee comes to request it, you may reach a level where reason number 1, 2, or 3 apply. So be thoughtful. You document very well. Make sure that the chief operating officer, chief executive officer, president, director of something, director of HR, somebody in a position of authority is the one that makes those decisions, that they are in writing, and you are required to keep it and have it available for inspection from the Department of Labor investigators. And I would expect some pushback on this, so be sure you're doing a good job of documentation. All right, a little update on Minnesota unemployment. Very short. The first is that people are getting an extra $600 on top of their weekly benefit. The federal government provided those funds, and it results in some employees actually making more money on unemployment than they would if they were employed with you. So it certainly disincentivizes employees from returning to work. I don't know if that was the intent, but that's the result. I have not done the calculation, but a colleague of mine that I was speaking with earlier this week did a spreadsheet and determined that if an employee was making less than about $69,000, they actually make a profit being on unemployment. And that if an employee makes more than $69,000 a year, that their unemployment, they're actually making less on unemployment than they would if they were working, which is typically what happens. You typically make less than you on unemployment than you do when you're working. So that's a thing to realize, that there's an incentive for employees not to return to work even if work is available. So you're gonna have to manage that very well. The second thing that is impactful to Minnesota unemployment in the last couple of weeks is that Governor Walz signed an executive order that eliminated payouts of PTO from offsetting weekly benefits. Typically, if your weekly benefit was, let's just say $500 a week, and when you ended your employment or went on layoff, the company paid out $2,000 in gross unused vacation, you wouldn't get an unemployment check for 4 weeks, essentially. It would offset. Governor Walz's executive order changed that, so an employee could get unemployment, and if they terminated their employment, you paid out their PTO, or they requested to use their PTO, they would just get extra cash, essentially. So be aware of that. And that's pretty much my portion of this presentation. So I'll just bring you over here to the very end, and that is that, if you have questions about human resources or about employee issues, or you want me to help you walk through this analysis for your company, you can reach me at the number on the left there, 218-213-7162. We're actually co-located with Anderson, Coeity, and Asuma, and we're partnering together on all kinds of client issues so that we can provide the best holistic answer to the questions affecting your companies. We know it's not easy to be making the decisions that you're forced to make right now, and the uncertainty, and the few things that we can provide is sound, solid information that's thoughtfully prepared for you so that you can make the best business decisions for your company. And so I want to appreciate you for viewing this webinar. Again, in a separate webinar, we're going to have Craig take over his portion, which is all of the tax credits and the SBA loans and the payroll protection funds, and help you really parse that out and understand that. And so that'll be uploaded to the Church and Associates YouTube channel as well. And that way, if you're interested in the HR stuff that I just went over, you can access that quickly. And if you're more interested in the in the financial stuff, you can access that quickly as well. So with that, I appreciate your viewing this webinar. I appreciate your support. And again, if you have questions, go to our website, give me a call. We're here and available 7 days a week, 8 to 6 p.m. Our phones are being answered in order to help you through this time. So thank you very much and have a great day.